All right, we can begin. Commence, noting that we have another session at 20 hours, so we can begin this one. So basically today, please just confirm if you can see my screen even before I start. Just confirmation that you can see my screen.
Yes, we can see it. We can see the screen.
All right, thank you for that. So we'll continue with Tort. That's tonight, and what you're seeing on the screen is our topic for tonight. So we're basically looking at trespass to the person. That is what we're looking at tonight. So this is also another kind of tort. The last time we looked at tort law, we looked at negligence as a type of tort. And then today we're looking at trespass to a person. So this is, when we're talking about trespass to a person, you're going to find out that this is a very intentional type of tort, because it mainly deals with interference as to a person, with regards to a person. Remember, when we defined tort, we said a tort is a wrongful act that is committed against a person or his property, as the simplest definition we could give. But now we're looking at a tort that is committed against a person. So basically, this lesson for tonight is summed up into three categories of under this that we're going to be looking at. Specifically, we're going to be looking at assault, we're going to look at battery, and we're also going to look at forced imprisonment as being factors or being limbs that have to do with trespass to a person. So a very good example of trespass to a person, for example, is by striking or putting a person in fear of being struck, by unlawfully restricting another person's freedom of movement. So this particular example gives us the three limbs to which we'll be looking at in consideration tonight. So we're saying striking of a person. So if somebody strikes you, they basically commit trespass against you, because trespass, we're looking at something that is done against your person, and something that is done directly. You will notice that the law mainly speaks about trespass done against your person. So it doesn't mean, don't take it in the literal sense. What basically that means is against your body. Okay, it doesn't simply mean that it's something that is done against another person. But the term itself says your person. I don't know why at times the law is like this. The English of the law does not English at times. So yes, so under that, a very good example is striking. If I strike you, for example, if I slap you, I commit trespass against you. Or if I put you in a position to which you fear that I might strike you, I also commit trespass against you. Or for example, if I restrict your movement, I commit trespass against you. And these three examples is now what we're looking at as the three limbs under trespass to a person, being battery, assault, and forced imprisonment. If we go into the criminal setup, we're going to discover that battery and assault are used interchangeably. However, when we're looking at it at a civil point of view, and I believe by now we understand what it means to when I say civil and when I say criminal. These are basic terms I believe that we now understand. So when we're looking at the civil aspect, battery and assault cannot be used interchangeably, because these are two different things, and we'll discover them. We'll understand further as we go on. So what are our objectives for this topic? Number one, explain the general principles concerning the torts of battery and assault. Should be able to do this at the end of this unit. Secondly, should be able to describe some of the factual situations in which a person will have the right of action for battery. Basically, you should be able to understand what facts would then give you permission to bring an action against the person who has committed battery and the person who has committed assault. What facts would provide that you bring an action. Thirdly, demonstrate your problem-solving skills in areas of torts. Okay. If you look at tort law and many other courses, you're going to find out that these are very relational courses because these are things that we encounter on a daily basis. At times, maybe we may not fully understand them, but when you delve into these aspects, then you'll be able to understand, no, this and this, it means that that has to be done. So these are very, very um, relational things that we encounter on a regular basis, I would say. Now, that's the beauty about the law, I think, because many of the things that we do are things that we experience on a regular or daily basis. Then, number four, we should be able to analyze some of the leading cases in the area of battery and assault and be able to apply them. Remember, our law is mainly about case law, the statutory law, but mainly it's always case law, okay, most of the times, because you want to build up a very good case. You want to win your case, but most cases, in most instances, you must provide authorities, in other words, that would favor your case so that the court rules in your favor at the end of the day. So you should be able to not just know these things basic in a basic setup. You must also be able to know the authorities that support each and every particular limb that we're going to be looking at. Okay, so trespass as a tort. Okay, so trespass as a tort is meant to protect people's persons. As I said, the English in law does not English most of the times. Protect people's persons, simply protecting your own body. Three of them include battery, assault, and forced imprisonment. Okay, so let's look at these three limbs in specification. The first limb we're looking at is battery. Battery is a tort. Okay, although it's also can be a criminal aspect when we're looking at it in a criminal point of view. But for now, let's delve into it as a tort, as a civil wrong. So, example has been given here. A will commit a tort of battery in relation to B if he touches her when he has no lawful justification, excuse for doing so. So, battery arises when you infringe on somebody's body, basically without their permission or justifiable excuse to do so. I just come to you and I shake you up. Okay, I just come to you and I slap you. I have no right to slap you. So basically, I touch you and I, in a certain way, in that I have no justifiable reason to do so. Now, remember, it's not just about having a justifiable reason. That must be a lawful justification. You see, as individuals, we may have certain justifications, but the question that the court might ask or should ask is it a lawful justification? You may have your good reasons, but if those good reasons do not fall within the confines of the law, then you cannot say that you had a valid justification for, infringing somebody's body. So it's mainly force that is exerted on a person. I come to you and exert some form of force on your body without your permission and without any lawful justification, then I have committed what is known as battery. So battery is intentional direct application of an unlawful force to another person. This definition gives us the three elements of battery. Remember, in law, many of the times, especially at preliminary stages, we're going to be talking about an offense, and we need to know that every offense must have elements that should be present so that we can justify and show to the court that actually this offense has actually arisen. It's not just about saying this battery must be able to buttress the relevant elements before the court for the court to rule in our favor. So the definition of battery, simplest definition, is that it is intentional and it has to do with direct application of an unlawful force. Remember, the force must be unlawful, unwarranted, unsubstantiated with regards to the law, something that the law does not allow, okay, to another person. So this definition then gives us the elements. So number one, there must be unlawful force. Authority is the case of F and West Berkshire Health Authority, okay, which talks about saying the force that must be used must be that force which is unlawful, especially the force where one does not have the authority to act or does not have consent. A very good example. is a medical practitioner who is, let's say, decides to operate on an individual. But remember, under medical ethics, I don't know if you've reached medical ethics or you're looking at medical law. A medical practitioner cannot treat a person in a way that that person has not given them consent to do so. So a medical practitioner can actually ascertain by their own expertise that the right method to use here, for example, maybe it is a childbirth situation, and they say because of these particular conditions that we are in, the only possible way of delivery is by a C-section. Okay, so that particular mode must be approved by the person to whom medical treatment is being administered to. So if that person does not consent and you still go ahead and you still deliver, you have used unlawful force. Okay, why? Because the person does not give you the permission to do so. Um, I come and slap you out of the blues. Did I give you permission? Did you give me permission to slap you? No. So anything, so especially something that falls from a non-consensual relationship becomes an unlawful force. Any force that is exerted on a person without permission becomes an unlawful, like in the case of F. West Berkshire Health Authorities. A very good Zambian case is, I would like for you to look at that case. I think it talks about this in a very good way, and you also be able to use it in medical law. Kachasu. Kachasu and the Attorney General. Yeah, look for it. It's Kachasu University Teaching Hospital, Kachasu versus University Teaching Hospital, and the Attorney General. It is a Court of Appeal case. So it had to do with somebody who was not given consent to administer medical treatment. I think it was a Jehovah's Witness. I think it was a blood transfusion kind of situation. I don't know if we have Jehovah's Witnesses here. So it was a blood transfusion kind of relationship. And the person did not consent. So the court said, no, there's battery here because there was unlawful force because there was no consent that was used. So you might want to look at that case. It is actually a precedent case that we have here in Zambia. It has set that precedent. Then intentional is the other element. We're saying it must not just be unlawful. You must have had the intention to do so. A very good example here is given such that, let's say uh, D need not intend the consequences of his actions. So a person does not need to intend the consequences of his actions. The case that you may look at is Wilson and Triangle, 1986. So what this basically means is this. I'll still go back to the medical practitioner type of example. What this means is this. The medical practitioner has stated that the procedure that we must use here is a C-section. And they still go ahead and use a C-section without your permission, okay? And the child is delivered and in a very well manner and everything is done excellently. That still does not negate the fact that you had no permission to act. So your intentionality does not look at the consequences of why you've decided to do such. So your conduct is not put into regard. It doesn't matter what consequences you were looking at the end of the day. So what this basically means is that the court will not look at the consequences. The court is going to be looking at the conduct itself. Okay, was it intentional for you to conduct a C-section? Yes, it was intentional because you had decided that I'm going to use a C-section. Okay, so meaning it has to be force that you've used that is intentional. You've used force to conduct a C-section which were not given permission. So even if the results are good to the court, it doesn't matter. Okay, I think this principle was also espoused in the same case that I mentioned, the Zambian case, the Kachasu case, Kachasu UTH and the Attorney General. While the court stated that, what did the court state? Well, the court stated that even if a medical practitioner had operated on a patient and everything went well, it still does not negate the fact that they had no intention and they will still be found liable for battery. So even if everything goes well, you still have the right to go sue a medical practitioner. You still got the right to sue any person, even if they intended well on you. So battery has no intentionality, doesn't matter as long as you've done something that is wrong. Okay, direct application. Direct application simply means that it must be done by your hand. Okay, by your hand does not, we're not saying in a literal setup, but we're basically saying that at least there must be some control of an element or a part of your body that goes and does it. For example, a medical practitioner uses whatever tools those guys use, and maybe they're operating, so it is being done by their hand. So the force must flow almost immediately and without intervention from these actions. It must flow just right there and then from you without any intervention from what? From these actions. Simply put, it must be done by your own hand and it must be immediate. Okay? You've done the unlawful, you've thought about it, you had the intention, and you act on it, basically. That's what this means. And it must not involve these actions. The person to whom you are being the person to whom you're being treated against. So for the tort of battery to be committed, a defendant must have directly, voluntary, applied force to the claimant's body. Supporting cases Stephen and Myers, 1830, volume 1. This is page 172. Should be England Reports 735. So basically it says that it must be direct and must be voluntary. Okay, the force that you're using, okay, must be direct and voluntary, applied force to a person's body. Okay, I am reacting to you on my own volition, not that somebody is controlling me. I have decided. I think this is what happened to the same case. The I'll be referring to the same case because the Zambian case that I've talked about gives us all these three elements. It is actually a landmark case because it goes even deeper and talks about these things. So when you read that case, you actually will be summing up everything that we're looking at here. So it talks about voluntary. So in that case, Dr. Manda was found liable because he voluntarily decided to give this person blood transfusion against their will. Okay, let's quickly run to assault, but you might also want to look at these cases. You might want to look at the case of Dodwell and Bafford, 1670. In this case, basically what happened is that the claimant was on a horse. The claimant was on a horse. Then the defendant has slapped the horse because it was botted. So the intentionality there, the intention of the defendant was that the horse was boarded, so it needed some sort of intervention for it to be proper and to do the right thing. So as he slapped this horse, the claimant fell off the horse and injured himself. So the court found that the person had committed trespass against the claimant because they had used force. Even though they had the intention to do good, what resulted was something bad, and they did not have the authority to do what they had done. Basically, that's why we're looking at intentionality, saying the intention, the consequences of what you're looking at does not matter, so long as the conduct itself is one that is done without one's permission. Okay, is something that is unlawful, something that is done without one's permission, or something that is prohibited by the law, then you will be found liable for such. Okay. Then we can also look at let's try and rush through to assault. Let's try and run through to assault. Okay. So assault and battery, as I said from the start, they look to be the same, but they're different under civil law. So a very good example is given here is that let's say the defendant, say the defendant will commit a tort of assault in relation to the plaintiff if he or she, okay, is about to touch the defendant, is about to touch the plaintiff and has no lawful justification or excuse for doing so. Okay, so Under assault, the distinction is this: you have the intention to touch somebody without justification. Under battery, you touch them without justification. So assault deals with threats, okay? Threats that would apprehend immediate infliction or unlawful force. Somebody raises their fist against you. They've not hit you with that fist, but the mere fact that this person has raised a fist against you, and if a reasonable person would apprehend that the raising of this fist entails that there is unlawful force that is coming after this raising of the fist, then you have committed a civil wrong of assault or a tort of assault. If you are doing so without any justifiable or excusable means or reason. Remember, it always has to be lawful. It doesn't have to be something that you can just say, no, because of this and this, the court will be looking at, yes, you've said this is your justification, but is this justification lawful? So that is a distinction between battery and assault. So battery can also be in form of words, verbally. I'm going to kill you. Okay, can easily arise to assault rather. So assault can also be in a form of words. Maybe you shout to a person and say, I'm going to kill them. I'm going to beat you. I'm going to do this. So if a reasonable person would apprehend that the way this person gave out his statement would lead to harm coming my way, then that person would have committed assault. Okay, so assault can be intentional act that is done by someone against another person, which would reasonably apprehend the immediate infliction or unlawful force. So long as I can apprehend that the way this person is acting, there's going to be force against him, then there is assault. Remember, with battery, was saying there's actually the unlawful force has been put into effect. However, under assault, the unlawful force has not been put into effect, but there are wheels and signs that show that force is coming my way. Remember, the test is always that the reasonable person must be able to actually show that there is this unlawful force. Okay. Now, we're talking about, can words amount to assault? Yes, words can amount to assault. Okay. So, can words amount to assault? Yes, words can amount to assault. A very good case is Ara and Highland. Okay. Now, this depends on the circumstances in which the words were said. Okay. It's not always that can amount to assault, but it depends with the circumstances in which the words were basically said. We can look at the case of Tadville and Savage. So, one of the considerations that we should pay a particular attention to when we're talking about assault, especially in form of words, is that what the court is going to be looking at is, did the person have the capacity to fulfill his terms of his statement? It's not just about me saying I'm going to kill you or I'm going to shoot you. What the court will then look at is, did I have the capacity to kill you, or did I even have the capacity to shoot you? I may say I'm going to shoot you, but I don't have a gun. The mere fact that I said I'm going to shoot you will not carry water in court, or will not carry water anywhere else, because the court will then look at, did I have the capacity? However, if I said I'm going to shoot you, and I had the capacity to shoot you, the court will then apprehend that indeed there is assault. Okay, I'm going to kill you. Maybe I'm even holding something dangerous in my hand, or even a knife, to say I'm going to kill you. Okay, the court will say you had at the time at which you are giving out this statement, at the time to which you are uttering these words, okay, you were in a position to actually fulfill whatever you were saying. So you might want to look at the case of Tabville and Savage, may also want to look at the case of Ara and Island, okay, which talks about immediate. Ara and Island talks about immediate. It must be something that comes out immediately. Okay, it's not something that must come out after some time. Then you come and say, "No, I'm going to kill you." So there must be facts that lead up, or events, series of events that lead you to alter those words, or to bring out that statement. But it must be immediate. It must follow a series of events. Okay, for you then to come and give out those words, not after it's taken ages, after the series of events have elapsed. Maybe there was a fury, and then someone comes and says, "I'm going to do this." Then it is following that series of events, but not after the fury has come down. And then after some time, come and say, "No, this and this." Then we cannot say that there was assault that amounted, that gave rise to such. Now, let's try and look at the last limb. The last limb we're looking at is false imprisonment. Now, you're going to agree with me that every time we're talking about, many times when we hear the word forced imprisonment, we're thinking about restraints in form of prison or a correctional facility. Many of the times, that's what we're looking at. Many of the times, that's what we're thinking. When we talk about imprisonment, we're thinking, oh, somebody has been jailed in prison, somebody is has been incarcerated in a correctional facility or at a correctional facility. So many, that's what we think. However, when we're looking at forced imprisonment under civil uh, aspect, especially under tort law, we're not basically looking at a prison per se. We're looking at restraints in any bounded area. If I have confined you in any bounded area, then there is imprisonment. Remember, every time we talk about imprisonment from a layman's perspective, there must be some authority that is restraining you. In many instances, the police. But in this case, we are not looking at it from an aspect of the police only restraining you, but we're looking at it. Remember, tort is a civil wrong. So we're looking at wrongs against individuals, wrongs against persons. So in this particular setup, we're looking at restraint that is occasioned not by the police, but occasioned by any other person. So long as I have restrained you in a bounded area, an area where you cannot escape. In other words, a bounded area is an area where you are limited to your freedom of what? Your freedom of movement. So if I limit you from your freedom to move, then I have restrained you and I have forcibly imprisoned you, especially if I do so without any lawful justification or excusable justification within the confines of the law. Remember, sometimes somebody may restrain you maybe because you want to commit an offense. Okay, that becomes a lawful justification. However, if I have no lawful justification and then I restrain you, I think a very good example is that is this dramatic cause. It's not dramatic. Uh, that's on a lighter moment. Domestic relations and domestic relations or family law. Others call it domestic relations. Others call it family law. I think an undergraduate's family law mostly. So when we're looking at domestic relations, for example, we tend to find sometimes the situations where a husband restrains the wife from leaving the home. I think I don't know if you've experienced such or you've seen such situations, but they do exist such situations where a husband restrains the wife and does not allow the wife to leave the home setup or the house. So that becomes forced imprisonment. It is not something that is allowable under tort law. It becomes force because you are restraining her freedom to do what? Her freedom to move. And when we're looking at freedom of movement, it is actually freedom of movement is a right under the Zambian constitution. So it becomes very much imperative that this is something that the law won't take lightly. Because when you go to Article 13 of the Zambian Constitution, you're going to find this right. And the Bill of Rights is very delicate for a portion of the Zambian laws, Part 3 of the Zambian Constitution, because even just the amendment of that portion of our constitution must be done to the people themselves through a referendum. So it just tells you how important it is. So now you restrict someone's movement. So it becomes something very, very, very trivial. Not trivial, it becomes something very, very punitive in action, or punitive in measure if you're found in want. So when you constrain somebody to a bounded area, then you falsely imprison them, especially if you do not have any justifiable reason to do so. So if you are a victim of such, you may go to court and you may ask for compensation for psychological, physical, or economic injury that was occasioned by the imprisonment. Okay? Because the mere fact that you've been imprisoned, the court will infer that you suffered psychological injury because you are confined, you're restricted to your movement. Physical and economic injury, if you can prove that actually you lost out economically, maybe because you would have um, benefited economically if you had the freedom to move and could have done some activity that could have brought you some money in short. So you can claim for such. So that is what we're talking about when we're looking at forced imprisonment. So forced imprisonment mainly just has to do with restraint of another person in a bounded area without any excusable, justifiable reason premised on the confines of what? Confines of the law. So an example that is given here is, let's say A will commit the tort of false imprisonment in relation to B if he does something to limit her freedom of movement to a confined space when he has no lawful justification or excuse for doing so, just like I was saying. So you limit somebody to a bounded area and you had no lawful justification or excuse for doing so, then the tort of imprisonment has been committed. Okay. So a defendant must have performed a positive act. Whenever we're talking about false imprisonment, you must have performed a positive act. Now, what do we mean when we say you must have performed a positive act? It simply means that you must have acted in a way that limits somebody from moving. Okay. Your actions must make it impossible for somebody to live freely. I guess people shouldn't be thinking outside the box for them to live. Okay, so in other words, that's what we're saying. You might also want to read the case of Mbasongo, Mbasogo, and Logo Limited 2006. So in this case, this is what the court actually stated from what I was actually talking about. Okay, this mainly does with assault. I don't know why it's here. So it says the threats made by pickets to those miners who sought to go to work were not an assault because the pickets had no capacity to put into effect the threats of violence. So this was a statement that was made by the court. You might want to read this case for you to understand the insights of it, but it was mainly a mining perspective, and there were threats that were being issued out. And the court had to then conclude as to whether assault was occasioned. However, the court simply stated that because the people that gave out these threats did not have the capacity to put them into effect, the violence that was threatened was not capable of being actualized, then the court held that there was no assault, basically. So when we're talking of assault, we're basically stating that there must be something must be put into act. Okay, is assault. The claim of assault must be put into act. I also want to read Thomas and Nan case. Okay, very good cases. So in this case, I think there's a brief explanation down there. Equatorial Guinea. So maybe let me just try and talk about the facts quickly. So the president of Equatorial Guinea uh, thought that there was going to be harm that is going to be done against him, against a certain group of mercenaries. However, these mercenaries were reported to have been arrested in Zimbabwe, and he perceived that because this group was arrested in Zimbabwe, there's probably another group that is already within the country that is going to commit such against him because he had weighed that the mercenary is planning to harm him. So the court mainly stated the position that we talked about and found that there was no case that he could raise against the mercenaries because he couldn't show that there was any capacity for them to harm him, especially looking at the fact that the people that he was talking about in specification were arrested in Zimbabwe. Okay. So when you're talking about threats, the first thing the court is going to be looking at, like, it's not the fact that a threat has been given. It's not the fact that you've had waged that there is a threat against your life. What the court is going to be looking at is the in your life. Are they in capacity to harm you? And the court simply held in this case that the people that were being referred to were not in the capacity of harming the president, especially so that those people that he was referring to were already apprehended in Zimbabwe. So there was no reasonable justification, okay, for them to have considered such. So you might want to read these other cases. You might want to read the case of Ara Bonewoods, Community and Mental Health. Okay. In this case, the court simply had to look at the requirement. Okay. For one of the requirements for forced imprisonment, what the court held that there is no requirement that the claimant be aware that he has been imprisoned. So when you go and you are claiming for forced imprisonment, there is basically no requirement for you to show that you were actually forced in prison. Because, sometimes you might be, maybe let me read this statement that the court made from this case, Lord Atkin. Okay, Lord Atkin stated that it appears to me that a person could be imprisoned without his knowing it. I think a person can be imprisoned while he is asleep, while he is in a state of drunkenness, or while he is unconscious and while he is a lunatic. So what Lord Atkin was basically stating here is that you, as a person who has been in prison, you don't need to prove that you knew that you were in prison, and the defendant does not need to state before court that no, this person knew that they were in prison, so they could have escaped, they couldn't have done that and that. So, for example, you may be in prison while you are asleep. You may not know it. Okay, you may be in prison while you're in a state of drunkenness. Somebody may be constraining you because you are in a state of drunkenness, or somebody may constrain you because you're unconscious or because you're a lunatic. Okay, basically somebody who's just lost their mind and you're not capable of reasoning well at the particular point. So in such situations, you don't need to prove before court that you knew that you were in prison. Okay, that you don't need to go to court and prove that no, I was in prison, I knew that I was in prison. So you don't need to prove that. The mere fact that we could show that there was restraint, even when you did not know that there was restraint, is already sufficient for you to establish a cause against a person. So you might want to look at the case of Robinson and Behrman Fury as well. And you might also want to look at the case of Davidson and Chief Constable of North Wales. So you will discover that I'm moving a bit quickly because of time, and we are done with this lesson basically. I'll just summarize what I've said. But the good part is that you'll be able to access this this class. You'll be able to access it, and when you access it, you'll be able to pick through these notes and probably maybe even write down the cases well while you're accessing a recorded one. So when we are looking at, let's summarize forced imprisonment. What must we be looking at? Number one, restraint. Restraint must be complete. That's one of the elements. There must always be restraint. So there must be no means of escape. Okay. So me as a person, I must reasonably be in a position where it is hard for me to escape. Okay. So sometimes, sometimes the defendant can come to court and say, no, but the person could have escaped, could have gone through this part, through this part. So what the court needs to look at is, if is another reasonable person in the situation of the claimant or the plaintiff, could they have reasonably thought of saying they could escape, they could leave from this place and that place? Or should it have been something that should have been outside the box? Should they have thought outside the box for them to be able to escape? So long as they could start thinking so much, okay, so long as they need to think outside the box for them to escape, then you've restrained them. Okay, because living must be easy for them to live. Okay, that's what it basically means. Restraint must be complete. Especially you need somebody to think of how now they're going to go out. Okay, the last thing is Clement's knowledge of confinement. Okay, this is what we looked at here. We said you must not be in a position, it doesn't matter whether you knew that you are being confined or you do not know that you are being confined, that you can bring to court on the basis that you are confined. So at the actual time, you don't need to have knowledge of being confined and proving to court that at the time at which this incident was happening, I was actually confined. No, you may be unconscious. Okay. And then after some time, you're in a very proper manner. Then you come and realize after that, actually, maybe this person had dragged you. And that's why you became unconscious because they didn't want you to go anywhere. Okay. And they wanted you to be at a certain point at a certain time and for some time. And they managed to do that. But at the time at which you were imprisoned, definitely you were unconscious. You didn't know what was happening. You were not aware. And then when you're in your normal state, you realize that this person intentionally restrains you. Then you can go and claim for forced imprisonment, provided the person had no lawful justification or excuse of doing such. So, knowledge of the actual imprisonment does not matter when you're bringing an issue or a cause against somebody for forced imprisonment. Remember, knowledge only has to do with at the time at which you are confined. Did you know? It doesn't matter whether you knew, you did not know, as long as you find out later on that you were actually confined, then you can bring such an action. Okay, because personal liberty is supreme, okay, and it is supported even by the Zambian Constitution. So basically, that is what we've been trying to look at tonight. So we've been looking at trespass to a person, and we say trespass to a person basically has those three limbs. There's assault, there's battery, and then there's forced imprisonment. And we said assault and battery are two different types. Battery deals with unlawful force without somebody's permission, okay, or something that the law does not allow. Then force imprisonment, then assault is mainly a threat. Okay. Then we look at the other aspect, which is forced imprisonment. So because we need to go into another class, which will be starting very soon, end it here and allow questions. Okay, thank you.
Good evening, Council. If I may go ahead and ask the first question. So I was thinking about a scenario where a doctor, say, administers blood to a patient. So now, doesn't that, for someone who's, say, Jehovah's Witness, doesn't that now support the doctor in a sense because doctors also have an oath to fulfill, which is the Hippocratic oath, which is to save life. So doesn't that give them the power to administer such treatment in order to save life? Thank you.
All right. Thank you very much for that question. It's actually a very good question. And some of the debates that have been going on for a long time. I think I also did my dissertation based on that. So as a lawyer, you understand that the law itself has a series of hierarchy, a precedent. Okay, so you start looking at statutory law, which is mainly, which is the highest. Then you have case law, then you have common law, and you have all these type of systems. So Hippocratic oath is not statutory in Zambia, and it is not under case law. So the law as it is, okay, the law as it is, especially when you look at, I think I'll share some of these things. The same case that I talked about, the one that brings precedent in Zambia, is the Kachaso case. If you read the Kachaso case, the court actually found out that it doesn't matter. Okay, it doesn't matter what oath a medical practitioner has taken, and that whatever they've decided to do, as long as what they are doing is not something that has been consented to by a patient, a doctor does not have the right to administer medical help. So it is a debate. So from a reasonable point of view, it might seem it seems impractical, because you'll be looking at it saying this doctor is saving life quite okay, and at times the person might still survive. Interesting, in the Kachaso case, the court went on and stated that even if the person had survived once being given blood transfusion, so long as the person did not consent, they will come for you, ask for damages, and you might even lose your license as a medical practitioner, even when what you did ended up saving somebody's life. Because under the Constitution, there is this right that has to do with freedom of conscience, which deals with religious aspects as well. So by religion, Jehovah's Witnesses do not accept, and the Constitution upholds that part of society under the right of conscience. So you have the right to subscribe yourself to different religious setups, so long as they're allowed by the law. And on the other aspect, the court looked at it from an aspect of battery. Did you have the authority to do this against somebody's body, of which you did not have the authority because the person did not consent? So as the law stands in Zambia, we do not have anything that can save a medical practitioner when they are administering medical health against a person who did not consent to such. So as the case is, even if the person survives, okay, even if a moral aspect of it will say it's the right thing that the doctor did, but it doesn't matter. That's the law, except our law changes. So maybe as lawyers we would want to change that law. I don't know. Maybe some should be advocates to change that. I don't know what others think, but that's the position. So I hope I've answered your question
adequately. Thank you.
All right. Thank you, Counsel. This is Sydney. My question goes to the battery issue. Because in the battery, you say this is the intentional direct application of unlawful force to another person. It is unlawful in the sense that this person has not given the permission, either to be slapped or either, to be inflicted with the pain and all that. Now, coming to the same, and then you gave us an example of the Kachaso versus the Attorney General XYZ. But I wanted to find out what happens to the cops, because a couple of times the police officers would actually beat people. They'll come with their short buttons and everything. For me, that comes to the issue of battery at the end of the day. And there are times they end up even assaulting that person. So, and looking at how the police is no longer a force, but it's a police service. So would one sue the police, for actually, for battering that individual or for assaulting that person, based on the way you've actually explained under battery tort? Over.
All right. Thank you very much, Counsel, for that question. Very practical question. So the answer is yes. You may sue the police. You may sue that officer working under the Zambia service. So you may sue them using the Attorney General because it is a civil service or government office in short. So you may sue that individual using the Attorney General. But why we have these prevalent situations is because we don't really have people that would stand up and help them, especially lawyers. Lawyers love money. don't just want to stand up against something, except if maybe it's a client and then they're giving you money and then you represent them, and that's when justice at times is done. So justice is not always done because the people that know these things, they want money. So if money is not present, they won't act. They will sit down. So that's why we're seeing many of these things, because they're being done mainly to people that are vulnerable, don't know their rights, and even if they know their rights, they don't know how to go about it. That's why in practical setup, you're going to find out that the police service and lawyers are not really friends. They're not really best of friends at times, because lawyers seem to be much more, they seem to be more vocal because they seem to know everything, and at times police are lowered down. So yeah, there's all that. So at the end of the day, as it is, you may sue the Zambian police. If you look at our constitution, even when you look at Article 15, it prohibits torture. So we see these things happening a lot of times, and at times it's also political, because our systems also want to protect their own systems unless somebody speaks up. I think we've known some other example is the notorious C5, who would shoot people even without justifiable cause, and then they're protected under the system because they don't really have people to stand up and take action against such. But in actual sense, especially the example that you've given, that is battery. It's straight on battery, and you can actually sue that officer using the Attorney General, or you may sue them in the individual capacity, but call also the Attorney General and put them as a second defendant, including their service commissioner as well. So you may bring three individuals, sue them, sue the commissioner, and also sue the Attorney General. So I hope that also answers your question. So can I please have the last question quickly,
Brilliant.
so that council may go through with the last with our next session.